there's still more that will trickle in, but if you have a pretty good idea, you can calculate an estimate of your inheritance tax and also the outstanding debts and make sure that you have enough cash. If you don't want to invest the decedent's money in a 6-month CD where the money's locked up. You want to make sure that you have liquid assets in order to cover the debts and also to make the discount payment to the Department of Revenue at 3 months. You get a 5% discount if you pay the tax at that 3-month window. And you don't have to file the return at 3 months. You only have to make a payment of the tax, and then you'll get a credit when you file the actual return at 9 months. Which 5%, you know, you're not getting a 5% return on your money these days in any savings accounts, so that's pretty good. At 6 months, you have the option on the federal return to revalue all of the assets, and this really has to do more with securities. It's called the alternate value. In case the market has taken a wild swing, either high or low, the federal government will allow you to pick either, but that's only the federal government, not the Pennsylvania. And then at 9 months, all the returns are due. For federal, it's called a Form 706, and for Pennsylvania, it's called a Form 1500. And the returns are due on that date with all tax being paid. And then the tax rates for Pennsylvania are 0 for your stated death value or the 6-month value to use on your death tax return. Spouse, 4.5% for your children, grandchildren, parents and grandparents, 12% to your siblings, and that includes step siblings as well if you have step siblings, and then 15% for all others, cousins, friends.
Live-in partners. So if, you know, just last week I was doing estate planning for a couple that was not married and really didn't intend to get married, but were living as though they were married and frankly intended to probably live all their lives as if they were married, and they had no interest in getting married. Whether that interest spiked at all after we went through these rates, I'm not sure, because the if they got married when the first one died, the second one would inherit everything. They were giving everything to each other, death tax free in Pennsylvania. And their estate was worth about $500,000. So 15% of $500,000 is about, what's that, about $75,000? That sound right? So, you know, you could buy a pretty nice wedding for $75,000. So I think after I told them that, I think they're rethinking maybe getting themselves a preacher. And just the federal estate tax rate is, when you get above that $2 million level, you're going to be about 45%. So certainly the techniques we've talked about in other seminars, such as the credit shelter trust, the disclaimer trust, life insurance trust, gifting, charitable donations, all those things are things that you have to be thinking about in terms of planning your estate and trying to avoid federal estate tax. Some of the other tasks that have to be taken into account. The decedent, when the Lord took that decedent, owed income tax, unless you die, I guess, at 12/01 on January 1st. I don't know, would you still owe tax? I don't know. It depends on whether you've gotten any income in that time. But if the decedent got enough income, and most people do if they, you know, live even a couple months, you're going to get over that income tax threshold. And so you've got to pay. The estate is responsible, lifetime 1040, and PA 40 have to be filed. Prepare and file estate income tax returns. Remember we said how the estate is like a person. It doesn't have legs, but in the eyes of the law, it's a person. Well, if the estate is generating income And remember, Sarah was talking about, return on that, the estate itself, pay income tax returns, and for as long as the estate is generating income, which is an incentive to in more than 1 year. Because the longer the estate lingers and the longer you get the thing wrapped up in 1 year, so that you don't have to file estate tax returns getting interest, the more likely it is to have to file those tax returns in subsequent years. Distribution of the estate, usually after the death taxes are filed, and that brings us to the estate accounting. Receipt and release is prepared and returned by beneficiaries. That's an informal way of administering an estate, and that's how most estates are administered now. Probably would file a formal accounting with the court using very standard was what your distributions were in terms of debts and what the proposed distribution is to all parties. That's a very tidy way of doing it. It's a very time-consuming way. The process, the formal accounting process that the court will make every dollar add up undertaking, and it takes a lot of time. There are some benefits where there's some question about who gets what. You will file a formal accounting and a statement of proposed distribution so that people can then have a forum to come and fight with the judge, not fight with the judge, but fight with each other in front of a judge as to who gets what. And if people won't do it informally, and I'm going to describe that process in a minute, sometimes you just have to go through the formal process. The informal process of receipts and releases, it's basically about a 2 to 3 page document where the requires, if you're going to file it with the court, is a very kind of strict, the executor says to everybody, and this is usually in a family situation, sometimes these are called family settlement agreements also, where everybody gets along, nobody's fighting with each other, everybody knows what the assets and liabilities were, everybody's on the same page is where you use this informal process. But the receipt and release is about a 3 page document that says, I, the executor, have given you, the beneficiary, access to everything in the estate, all the records, all of the receipts, all of the expenditures, the will, the account information. I've provided the inheritance tax return to the, and if necessary, a federal estate tax return to you. All the income tax returns have all been made available. And by signing this receipt and release, the beneficiary is saying, I'm satisfied with what the executor has done, that my share of this estate is X dollars. And I, with what the attorney hired by the executor has done, and I am satisfied, and I promise that if something comes up, and this is like the DPW thing where you forgot about the lien and you owe $75,000, I promise that if something comes up, I will reimburse the estate from the money given to me to protection for the executor and frankly for the attorney for the executor in case something went wrong. And it may not have been anybody's fault. It may be just something, a debt that popped up, pay any debts or any liabilities that pop up. It is a wonderful that nobody was aware of, because if you advertise, by advertising, people then have a year to come forward with claims. And you may have gotten the estate in a shape where you can distribute before that. But then 11 months later, somebody pops up and has a debt. That receipt and release obligates the beneficiary to pay back the estate and the executor to make good on any liabilities that are outstanding, that were unknown. In fact, sometimes most estates now are finalized by these receipts and what, or did the executor properly manage the money, properly propose a distribution? Do you have those formal accountings? Sometimes people name banks or trust companies as the executor of a will. Banks tend to be most comfortable with the formal accounting because the formal accounting gives a judicial imprimatur, a judicial approval of the accounting, and it does give more protection to the whoever, most cases, all the protection that anybody needs. It's informal, it's less expensive, there's less, at least in most cases. There are some institutions, for example, if an accounting is filed, then the judge has to issue an adjudication approving the accounting and approving the proposed distribution of where the money goes. And then the court expects a status report to be filed saying that either the estate is open and why it's open, or that it's closed, and that has to be filed within 2 years of death.